Hawkins Mayor Susan Hubbard and the Hawkins City Council won't listen to me about shit. Let's see what the Texas Attorney General has to say about it.
You need to remember this and recognize the discussions of public business need to be kept to the meetings when you are in a quorum. You can talk to each other in the elevator. You can speak to each other when you run into each other at the grocery. I don't mean to suggest that you can't, but you need to understand that your discussions of public business need to be limited to the meetings. If you don't take anything else away from this presentation today, I want you to take the message that you cannot discuss public business in a quorum outside of a properly called meeting. Doing so could result in severe criminal or civil liability to you and your governmental body.
Okay then, I hope we're clear on that.
The Act requires that each governmental body shall give written notice of the date, hour, place, and subject of every meeting of the governmental body. Now, with regard to the subject matter, the notice must be sufficient to inform the general public of the subjects that the governmental body is going to consider during the meeting. And I think the best way to analyze this sort of issue is to look at a hypothetical notice and see whether it is sufficient. So here we have a notice for a meeting of the Tejas City Council. It has listed the date, the hour, and the place of the meeting. And then the first subject to be considered is the mayor's report. Does that subject provide sufficient notice of what is going to be addressed at the meeting? No. It tells you who is speaking. The mayor is going to give a report. But that language alone is insufficient as a matter of law to describe the subject matter of the meeting. Now, if this notice listed what the mayor was going to discuss under mayor's report, that would be fine. But the inclusion of boilerplate language like this by itself is insufficient under the Act to provide proper notice. We regularly see meeting notices that include language like old business or new business or executive director's report. The use of boilerplate language like that in all of those instances is insufficient under the Act. So if your governmental body is using language like that, you need to reconsider your agenda preparation and make sure that you're providing more detail about the subjects that are going to be considered at your meeting.
And we got that one out of the way, so let's go on to the next one.
So ultimately, whether a notice is going to be legally sufficient to notify the public of your subject is going to be a fact question. But if you're uncertain about how much detail to provide, I always encourage you to provide more detail rather than less. You're not going to get sued by a member of the public because you've provided too much information in your notice about what it is that you're going to talk about. But you very well could be sued if you don't provide enough information and the public is left unaware about the subjects that you're going to talk about at your meeting.
Yeah, I mean, there's always that, I guess, but what else?
All right, we've spent a lot of time on notice this morning, and it's obviously something that the legislature feels strongly about. There are a lot of requirements in the Act about providing notice to the public to ensure that they're aware of what it is you're talking about at your meetings. If the public isn't aware that you are discussing a specific item, then they don't know whether to attend and pay attention to that topic. So I want to wrap up this discussion today by addressing what can happen when a governmental body doesn't provide proper notice under the Act. Any action that is taken in violation of the Act can be void. It's voidable. And there's a case that exemplifies the consequences of not providing proper notice well. It's the Ferris v. Texas Board of Chiropractic Examiners case, and it's a Court of Appeals case that involved a board attempting to fire its executive director. It held a meeting in July and attempted to fire its executive director at that meeting, but it had not properly noticed that topic at that meeting. The executive director thereafter filed a lawsuit alleging that her attempted termination was void, and she was owed back pay from the time that they attempted to fire her. In December of the following year, so 17 months after the initial attempted termination, the board properly terminated the executive director at a lawfully convened meeting. And the board argued at that point that because it had rectified any prior violations of the act, she shouldn't be entitled to damages. But the court disagreed, and it awarded her 17 months of back pay, all of her benefits during that time, and her attorney's fees, despite that she had gotten a job with another state agency very shortly after she had been terminated. All of this was due to the fact that the board hadn't provided proper notice and had not taken an action in compliance with the act. I emphasize this because there is real civil liability that can attach to violating the act that you need to be aware of. Now, the first of those is the attorney consultation exception. And this is probably one of the most often used reasons why people go into closed session. Governmental bodies will often go into closed session to have a private consultation with their attorney. And the provision in the act allowing these closed sessions provides that a governmental body may not go into closed session with its attorney except when the governmental